Good morning, Mr. Watling. As I understand it, we're going to hear both cases together, and that you've all agreed with Clerk Mellon as to how the time will be allocated. So we will proceed first with you, Mr. Wadlinger.
Thank you, Your Honor. Good morning, and I also thank the Court for giving us the additional time we requested. I appear this morning on behalf of the Cape Cod Commission. My name is Eric Wadlinger. With me today is Doug Wilkins, appearing for the Alliance, and Charles McLaughlin, Jr., appearing for the town of Barnstable. We are here on appeal from decisions of the Barnstable Superior Court on a declaratory judgment action and a decision of the Energy Facilities Siting Board. The standard of review for the court is plenary on questions of law. There's no particular deference to the Siting Board on the construction, certainly of the Cape Cod Commission Act. And since the Superior Court made no ruling on the question of supersession, that question is before you de novo.
But I think you are party to this, that the initial claim that was in the exhaustion claim is no longer being pressed by anybody. Is that correct?
Yes, Your Honor. It was mooted by the decision of the board.
Okay.
The question of supersession is the primary matter I will turn to. The Cape Cod Commission Act, Chapter 716, provides an exclusive remedy for a party aggrieved by a development of regional impact or DRI decision. And that exclusive remedy is an appeal to an impartial, apolitical tribunal, namely the Superior Court or the Land Court. Cape Wind took no such appeal. Instead, it petitioned the Siting Board, whose members are appointed by the governor and serve at his pleasure.
But who have a very specific assignment with respect to the important question of energy in the Commonwealth. Very specific assignment.
That is so, Your Honor. But I would direct the Court's attention in the first instance to the Island Properties case, where this Court considered, in a decision written by Justice Kaplan, the interaction of the Martha's Vineyard Commission Act with the general law of the Zoning Act. At that point, actually, the Zoning Enabling Act. In that case, the landowner claimed that the Vineyard Commission Act must yield in favor of the plan freeze for subdivision plans required by the general law, Chapter 40A, at that time, Section 7A. The Court was able to find that the argument for supersession need not be decided. But Justice Kaplan said, "We do not minimize its apparent force, considering the emergency nature and comprehensiveness of Chapter 637 and the cogency of a legislative purpose to take into the statutory scheme all undeveloped land and water which are plausibly required as treatment as district of critical planning concern or DRIs." The Cape Cod Commission Act is a later variant on the Vineyard Commission Act. The Vineyard Commission Act was 74. The Cape Cod Commission Act is 89. The two are very similar. And the point that Justice Kaplan made there is that a later and special act, in this case, the Cape Cod Commission Act of 1989, as opposed to the 1973 EFSB Act, should take precedence in the event of a conflict. And the provision for an exclusive remedy...
If you're right, that means that if a board in Boston or in Haverhill or in Springfield were to decide against an energy project, that the developer could go to the Siting Board to override it, but if it happens in Cape Cod, you have to go to Superior Court. Cape Cod now stands in a unique place in the Commonwealth with regard to the Siting Board?
Also Martha's Vineyard.
And Martha's Vineyard?
Yes, thank you. Yes, Your Honor, and I would point to two things. One, Chief Justice Kilbourne, formerly of the Land Court, decided that Chapter 40B did not apply on the Vineyard. And he pointed out explicitly that the Cape Cod Commission Act said that the commission would be treated as a local board for 40B purposes, but there was no equivalent language in the Vineyard Commission Act. In the Vineyard Commission Act, there's no explicit language saying that the Vineyard Commission is subject to the siting board. Now, Springfield and every other place outside of those two counties in the Commonwealth would be acting under the Zoning Act, which long predates the EFSB Act. And so if one were looking at the sequence of legislation, one would say that when the EFSB Act was passed, the legislature was well aware of the Zoning Act and the subdivision control law, and by providing the remedy of a petition to the siting board, it took into account that zoning board decisions, for instance, would be petitionable, if you will, to the siting board. But the other thing I would note is that there is no case this court has decided involving a decision by a zoning board or a planning board which was overridden by the Energy Facility Siting Board. Now, that may simply be a historical anomaly, but
did the legislature intend to allow the Cape Cod Commission to essentially trump the views or trump the determination of the Energy Facility Siting Board with respect to the energy needs of the people of the Commonwealth as a whole?
Your Honor, I would point to the fact of the recent Oceans Act, where the legislature said explicitly that decisions of the Cape Cod Commission in the 3 miles offshore, which are county and state waters, for electrical generating facilities are petitionable to the Energy Facility Siting Board. So if they specified one particular category of energy development that can go to the Siting Board, by implication, the others cannot.
Maybe they just wanted to make it clear, because you've obviously raised the question.
Well, Your Honor, they've had, if you look at the sequence again, in the Energy Facility Siting Act itself, the term local government was initially present, and appeals to the Siting Board from local government decisions were allowed. In 1976, 2 years after the Vineyard Commission was created, the legislature amended the Siting Board Act to take out the phrase local government, which by definition included regional governments, and substitute the phrase local agency.
Well, clearly you're an agency of the Barnstable County government, right?
We are, but we're not a local agency, Your Honor, and that is very clear from Island Properties. It is very clear from this court's decision in the Home Builders case. It's very clear from the federal court's decision in Leisure Time Cruise Corporation, where the court gave the commission the power to exercise DRA power over a boat which was going to go outside the 3-mile limit to gamble.
So the siting board has no authority over decisions of agencies of county government.
Of regional government, Your Honor. There is only one county government, I think, in the state.
Well, you're an agency of Barnstable County
Barnstable
government.
County, yes.
Right, that's what you are.
Yes.
Okay, and you're saying the Energy Siting Board has no jurisdiction over agencies of county government.
Yes,
although
Your
it does
Honor.
have jurisdiction over local agencies and state agencies.
Yes, Your Honor, and I point again to Island Properties, where in footnote 25, Justice Kaplan pointed out that in the Vineyard Commission Act, it invites comparison with Chapter 40B, affecting low and moderate income housing. And the point is that it gets, if you look at the text to which that footnote relates, it relates to the regional viewpoint, not some narrow parochial local viewpoint, but a regional viewpoint. And the Vineyard Commission had only 6 towns. The Cape Cod Commission has 15 towns, plus Native American representation and minority representation. So the evil which the Siting Board is supposed to address, which is narrow parochial views of one town saying not in my backyard, is not really a problem with the Cape Cod Commission. The people in Provincetown, you could build this thing right off Barnstable, people in Provincetown aren't going to see it. The parochial localism, which the Siting Board is designed to provide relief from, is not present in the Cape Cod Commission. And if I may, I point out one other thing, and that is Chapter 40A, Section 3, provides a procedure where a utility which cannot build an energy facility because of local zoning can go to the DPU and say, give us relief. There is no equivalent procedure with respect to the Cape Cod Commission or the Vineyard Commission. And that is because, I would suggest, the legislature recognized that these are not purely local bodies. These represent regional decision makers, and they're not infected by any parochial localism. I'm afraid my time is up. Thank you.
Thank you, Mr. Wadlinger. Mr. Wilkins?
Good morning, Your Honor. May it please the Court, I represent the Alliance and the individuals named on the petition. I plan to focus on the fact that this project plans the private use of publicly owned tidelands. Now, as this Court has said on many occasions, the Commonwealth holds these tidelands in trust. It owns the tidelands, and it has to consider the public benefits and detriments. Yet, in this case, we have at least 3 instances in which EFSB and DEP has breached that trust. First,
Mr. Wilkins, with respect to the Chapter 91, and I can ask Mr. Salinger as well, why was no, I have what happened in DEP, but why was no certificate issued? I mean, why did they not complete the process?
well, we appealed, as is our right under Section 18 of Chapter 91, and it was quickly recognized, I believe, that this Court decision in this case would decide a number of issues that would be very material to our appeal. Those issues being the ability to consider the full impacts of this entire project, as well as the question of the DEP regulations, which is our third point. And so the hearing officer, although we made an original motion, the hearing officer ultimately on his motion decided that it was a good idea to stay those proceedings.
So in your view, as I take it, every federal or state agency that is reviewing any part of this project needs to review the entire project. How many layers of this kind of comprehensive review are you suggesting is necessary?
Well,
DEP, Energy Siting Board, federal government,
No,
Army Corps of Engineers?
I disagree with the premise of your question, Your Honor. The basis of our argument that the Commonwealth, as a matter of trust, needs to consider all the impacts that will happen within the Commonwealth is based on the fact that these are Commonwealth tidelands. Chapter 91 specifies the process by which they may be used. Federal agencies aren't going to consider that at all. Federal agencies actually will consider all the impacts in the federal
They
waters.
won't consider public trust aspects.
They only federal public trust issues. They will not consider state.
They won't consider Commonwealth
Exactly.
public trust issues.
Well, they may as a matter of comedy and completeness, but they don't have the trust that the lands are not impressed with the trust with respect to the federal government.
And what we're talking about here is putting a cable under such lands.
Well, no, that's not all we're talking about, Your Honor. We're talking about a project that depends upon putting the cable out there, and the project includes the turbines in the federal waters, which will have in-state impacts. So, for instance, the DEP 401 water quality certification, we didn't appeal that. I wouldn't strongly argue that there's an issue there to consider the WTGs. But as far as the AFSB's consideration, as long as it purports to issue a Chapter 91 license, it is engaged in a process where the environmental protections guaranteed by Chapter 91 will not occur.
Well, that's theoretical, but as a practical matter, that's not the case here at all. In fact, DEP has given very careful consideration to the 91 license issue and, in fact, has essentially made a written determination that it should be issued with terms and conditions, and all that EFSB is adopting that.
Well, DEP has done no such thing, Your Honor. DEP is in the middle of its process. Want to jump the gun, I suggested that would be illegal.
What do you mean it's in the middle of its process?
Because the DEP issues no license until it has gone through an adjudicatory hearing at which we are allowed to address Chapter 91 standards, not Chapter 164 standards. This is a substantive issue as to which standards apply.
That's your appeal.
Before DEP, correct. And DEP has not gone through that process. So it is both procedurally defective, it's substantively defective, and EFSB issuing this permit also has the wrong decision maker. So that's pretty much, I think, a full sweep in terms of the defects in relying upon the DEP written determination, which is just a staff determination, not made after an adjudicatory hearing. Now, EFSB...
What is it made after?
It's made after a paper review and a public hearing.
Okay, so there are submissions. I take it you made many submissions, as did others. There was a public hearing, and there's a written determination.
Yes, by staff. And that is not a DEP determination. And
But the DEP has authorized the board, the EFSB, to incorporate that determination into its composite certificate have to be.
Yes, as a matter of litigation, it did file a consent, but only the legislature can authorize the EFSB to issue a Chapter 91 type license. And there is no language here by the legislature authorizing the EFSB to do so. We have looked in vain for any reference to any kind of state tidelands or state property in the EFSB statutes. The appellees here have cited a provision that refers to all individual permits, approvals, or authorizations which would be necessary for the construction and operation of the facility. I suggest that language actually proves our point, because those are regulatory licenses. Those don't deal with the Commonwealth's title or the Commonwealth's trust. Those are licenses dealing with construction and operation. If we were dealing with construction and operation permits only, in partial response to Justice Cordy's question, EFSB might well say, well, we don't have to do the extensive review that the Alliance is asking for here. But in fact, in this case, the EFSB action means that DEP will never hold a hearing under Chapter 91 standards on the full implications of allowing the use of the Commonwealth's tidelands for this purpose.
And what you say, and basically when you say the full implications, you're saying again, it will be required of DEP to do what you say the EFSB should do, that is, take into account the full, as you put it, in-state effects, which means reviewing the entire project.
Exactly, Your Honor. That's my second point. Because starting from a common sense perspective, what landowner would allow someone to put cables over their property without considering the full impacts? Why
But doesn't
would
doesn't that allow the state to do what it indirectly, what maybe it probably can't do directly, that is assert direct jurisdiction over these turbines that are in federal waters?
No, Your Honor, and I think that the term jurisdiction has been thrown around here in ways that are inappropriate. The state has jurisdiction over its tidelands. It may choose not to license the use of those tidelands in order to avoid in-state impacts that are adverse to those tidelands. And here we have in-state impacts to navigation radar, a whole host of impacts that we've listed in our brief that I don't have time to go into. But no rational landowner would ignore those impacts in granting a license to go over its property. And in fact, the statute, EFSB's own statute, refers to environmental protection. It refers to public safety. Now, these are terms that apply to the Commonwealth, not just to a portion of the Commonwealth's environment, but all the environmental impacts.
Mr. Wilkins,
yes.
even if we did not agree with you with respect to the scope of the Section 91 review, the fact of the matter is, as I understand your argument, that there is no authority for the DEP under the public trust doctrine to delegate, pass over, consent to, authorize, acquiesce in a determination by EFSB as to the peculiar subject matter jurisdiction of the public trust doctrine, correct?
Exactly, Your Honor.
And so you may lose, if I follow your argument, you may get before DEP, you may have an adjudicatory hearing, which is the necessary prerequisite for the issuance of a Chapter 91 license, and you may argue, the argument that you've just made, it is unreasonable not to consider the full impact, and you may lose on that point. But that's not EFSB's jurisdiction to accept or reject that.
Exactly, Your Honor.
So that we don't have to say, in fact, it will be a conflict with an assertion of, a claimed assertion of, quote, exclusive federal jurisdiction, right? That hasn't been determined.
It's right. It's not EFSB's job, and so EFSB should not have wandered into these waters, so to speak. And if I may just briefly on my third point, Your Honor, if we do get before DEP, we have also argued that DEP's water relatedness regulation, which carves out this type of project, from the water relatedness definition, that is violating the statute, and that is the nub of our argument. It establishes a standard that is inconsistent with the standard that is stated in the statute. The statute says that it's water related if it cannot be moved from shore and requires location in the water. So that is along the lines of moot. Another example where DEP has limited its trust responsibilities by saying here's a host of issues that we're just not going to consider because we're going to consider it water related. So if I just may sum up, Your Honor, that this is an important case precisely because the Commonwealth's interest in tidelands is at issue. These are fiduciary duties, and the agencies cannot abrogate them, which they have done in 3 ways. It's not a matter of a locality interfering with what's going on. In fact, it is a matter of EFSB evading the Commonwealth's fiduciary obligations to administer its tidelands. Thank you, Your Honor.
Thank you, Mr. Wilkins. Mr. McLaughlin?
Chief Justice Marshall and Associate Justices, thank you. For the town of Barnstable, certainly taking all of the allegations in the 231A complaint as true as we must, this project harkens back to, at some levels, albeit without the personal involvement and personal risk, that which this court was so concerned about in Allen versus BRA. The potential for massive environmental damage should the worst happen is present in this case with regard to oil spills that we've talked about, with regard to the FAA issues that are identified that the court, I believe, still needs to rule on, and with respect to, frankly, another issue that is close to our heart, and that is the issue of mitigation that has all been barred from consideration by the EFSB because of this jurisdictional line that has been placed in the sand or in the water and has barred our examination before them of some of these effects that are directly impacting state interest and particularly Barnstable's interest.
I'm sorry, what's directly impacting Barnstable's interest?
The inability to look at any of the effects of the federal
wind farm
project.
You want to look at the wind farm?
I want to look at the wind farm.
All right. Have you had an opportunity to look at the wind farm? Federal process, any opportunity to participate in that process?
We have, and that process is, of course, ongoing, and thus far the final environmental impact report at the federal level, I would suggest, leaves a massive gap because the concerns that Barnstable's raised appear not yet to have been addressed. Obviously, we're still arguing.
How many agencies of the federal government are reviewing this?
MMS primarily. Army Corps did earlier, and then with a revised piece of legislation generated in large part because of this case, the baton was handed over to MMS.
Been going on for years.
It has, Judge, but it has.
And you've had lots of opportunity to participate or contribute or file?
Well, we have participated and attempted to make this known, and yet there is nevertheless this unwillingness to address so many of the concerns that we have and what the effects are.
Unwillingness to address or just addressing them differently than you would like?
In some respects, complete failure to address thus far, and that's on the mitigation issues that we're concerned about.
Mitigation issues?
Yes.
What do you want?
Certainly from the town's perspective, we're looking at massive unfunded mandates to be able to respond. We're going to be the first responder. Our guys are going to go out if there are incidents out there. We don't have a dime in money to do so internally. We need literally millions of dollars worth of equipment.
So it's not environmental. Well, okay. All right.
What requires you to make those responses?
But it is under 69.0, Your Honor. I would respectfully suggest that the public safety and public interest are two measures under 69.0 that do need to be considered by the EFSB.
What requires you to make those responses?
As a matter of, well, first of all, we are the closest responder. We can arguably stand by and do nothing, but in the case of keeping in mind that this project.
What if you stood by and did nothing because of a fire or because of a personal injury that occurred on the platform?
I'm not sure that there'd be any liability if that's the concern, but as a practical matter, we would be called upon. We are the nearest facility. We're the only facility that has a fireboat capable of getting out to the property, albeit it's grossly inadequate to respond to most of the emergencies that we might anticipate out there. But again, that's assuming that the project's going to be built where it is. Our position is that the EFSB under 69.0 had an absolute obligation to consider many of the risks posed by this as it affects Massachusetts interests. And we've attempted to, they've read into this, into their statutory...
Disposed by the farm.
Correct.
By the farm. The one in federal land that the
That's
federal
correct.
government is determining whether it's
That is correct.
appropriate to build.
There is a footnote to that, and we've raised, on behalf of the Conservation Commission, serious concerns about documenting presence of eelgrass and the like, which occurs in state waters and which has been ignored. But certainly the farm itself is the primary focus of our concern.
It's been ignored?
Yes, it has.
Eelgrass has been ignored? I thought there was quite a study of eelgrass. In fact, it was before the DEP.
Only in Lewis Bay, and we asked, because of the evidence that the Commission produced, questioning the photographic reliability of the remainder outside of Lewis Bay all the way out.
And
that has not been addressed.
have you had a chance to make those arguments before some agency?
We did, before
The
the
DEP?
EFSB. Before the EFSB, we did.
And also the DEP?
No, we have not made that argument yet
How
to
about as
the
part of
DEP.
the MIPA process?
About part of the MIPA process.
We made it, I want to be accurate in my response. We did raise concerns, and there were submissions under MIPA that the Commission was expressing. But our primary involvement with the Commission, with the Conservation Commission, was to the EFSB, and we addressed it in that.
I thought that what the typical procedure is to identify where the eelgrass is located and to identify in advance what the remedial measures would be if something goes awry. And the only thing that was permitted here by EFSB was essentially the response from the wind farm to the effect that, well, if something happens, we'll take care of it.
Correct, but it's an empty promise if we haven't documented existing conditions, and that's one of the points we raised in our brief, that if you can't identify what is there, then the promise to correct that which you have no knowledge of is a rather empty one, and that's all the Commission was asking for. Let's document what's there so that if remedial measures are required later on, that we have a baseline to compare it against. I'll just summarize, Your Honors, with respect to the concern. This Court has been even
Unfortunately, Mr. McLaughlin, your time is
Thank you, Judge.
expired.
I appreciate it. Thank you.
Good morning, Mr. Salinger.
Good morning, and may it please the Court. I'm Ken Salinger for the Siting Board and for the Department of Environmental Protection. If I may start with Chapter 91, a delegation of authority from the legislature to license facilities in tidelands need not refer to the public trust doctrine to be effective. The Court made that clear in the Fafard decision in footnote 10, where the Court listed a number, I think it was 4, of statutorily effective delegations of that authority, including the municipal powers to license shellfish aquaculture or weirs in tidelands, and none of those statutes that the Court said were effective mentioned the public trust doctrine. What we have here is a board acting pursuant to expressly delegate authority to issue a certificate in lieu of all individual permits, approvals, or authorizations that may be required by any state agency.
Go ahead.
You don't make any, it matters not that the word license isn't used.
No, the license is a form of authorization, and we point out in our brief that's clear from other parts of the Siting Board statute. The Board's interpretation of its statute is reasonable in that effect. The argument by the Alliance...
It may be reasonable. What is the strongest language for an express delegation that the EFSB has jurisdiction to assume the fiduciary responsibility of DEP in exercising its licensing authority under Chapter 91?
It's a two-part express delegation, but it's no less express for that. It's first in the Siting Board statute in Chapter 69K, the delegation of authority to issue a certificate in lieu of all permits, approvals, or authorizations. And one of those kinds of authorizations is the delegation to DEP in Chapter 1 to authorize, through a Chapter 91 license, structures in tidelands. And so those two together, Your Honor, constitute an effective express delegation by the legislature of that authority. Here, of course,
Did you say there was a second? I think you said there was two.
It's the two statutes together. It's reading the Siting Board statute, Step 1, together with Chapter 91, Step 2.
And what is the language in Chapter 91 that you are referring to?
The key language, Your Honor, is the language in Section 69K that authorizes...
Wait a minute, just get me to the language.
69K.
Yeah, what page are we on your brief?
I have the site, but not the page. Let's see. In our addendum, page 16, Your Honor. I'm sorry, page 17.
Okay.
Toward the bottom of that paragraph, 1, 2, 3, 4, 5, 6, 7, starting 7 lines from the bottom. The certificate shall be in the form of a composite of all individual permits, approvals, or authorizations. And authorizations include licenses, and
authorizations include licenses.
I don't have the site at my fingertips. I apologize, Your Honor. In our brief, we point out that there's a provision in the Citing Board's statute that makes clear that licenses is a kind of authorization. I can find that now if you wish, but it is in our brief.
Right, and then the Chapter 91 express delegation is Chapter 91 section.
Section 18 in our addendum, page 2, Your Honor.
Right. And the language that you're looking at there?
Well, it starts on page 2, but the particular language is on page 4, the first full paragraph. May be licensed after a determination that the structure shall serve a proper public purpose and that said purpose shall provide a greater public benefit than public detriment. Here, the Citing Board expressly incorporated the DEP's findings with respect to those and all other licensing requirements under Chapter 91.
But Mr. Wilkins says as to that point, that's the staff determination. There hasn't been an adjudicatory hearing. They haven't been able, the DEP itself hasn't considered the arguments that you need to take a much broader view, et cetera, and adjudicated that point.
And I think there are two complaints in there. Let me separate them. One, the Alliance complains that they did not have an adjudicatory proceeding before DEP. That's correct, but leaves out the fact that they had a lengthy adjudicatory proceeding at the Citing Board where they were able to...
Board,
where they were, if I could just...
Yeah, where they were able?
Where they were able to, the Alliance was able to, and did in fact raise before the board the very issues that they say they wished to raise at DEP. So they were not denied any opportunity to be heard. They were not denied any opportunity to press their arguments, the ones they press here regarding the Chapter 91 license, that the Citing Board, exercising this authority, should have looked not just at the impacts of the cable, which will end up buried underground and not interfere with the public trust rights at all, but should have looked at...
That's an interesting conclusion. Let's assume that you have your fiduciary hat on.
As
right?
the Citing Board did, yes, Your Honor.
You have a fiduciary hat on. You are a trustee, and there is a massive project going up on neighboring land over which you as a trustee have no fiduciary obligation at all. You can't even look at it. And the person who is putting up this massive project, that, by the way, is likely, not necessarily, but is likely to interfere with fishing, fouling, and navigation right up next to it, because if you are just a regular old New England fisherman, you may not want to go right up next to this huge, great big wind farm, which is not going to be small. And in exercising your fiduciary responsibility in connection with a request that in order to facilitate that great big project next door, you're being asked to just run a couple of cable lines. Do you think in saying, I'm not allowed to look at the next door property because that's on somebody else's land, that is a proper exercise of fiduciary responsibility?
Your Honor, in this context, the fiduciary responsibility that was exercised first at DEP and then at the Citing Board both came to the conclusion that under Chapter 91, the legislature having commanded that what should be looked at is the effect of the structure for which a license is sought, that it was proper to be looking at
I understand that, but then one might say, could one not, that such a delegation by the legislature is inconsistent with the legislature's fiduciary obligations under the public trust doctrine, and we are not going to assume that the legislature, sort of in a rather casual fashion, ignores its fiduciary responsibilities, and that is why the jurisprudence of this court, if it is anything, says it has to be crystal clear, no ambiguity, absolutely express. And so if you had under 69K something that said, and oh, by the way, EFSB's jurisdiction extends to lands that are subject to the public trust doctrine, that would be a tough case for Mr. Wilkins.
Your Honor, this court's expressions of the need for an express delegation really came in Moot and Fafford. The issue at Moot is not arising here. There's been no relinquishment of any public interest
Well, that's a
or
different
rights.
issue that Mr. Wilkins has about the water relatedness. That's a different issue, but that's not what I'm focusing on.
And the issue in Fafford does not arise in here. In Fafford, of course, the town of
I
Barnstable.
know there's a complete abdication, but I don't
That's
think
right.
that our jurisprudence really turns on, I mean, those are factual circumstances, I know those, but it's not a complete termination of interest. My question is the broader one, which is in exercising one's fiduciary responsibility, is one entitled, I mean, as a trustee, as anybody else, to ignore the very essence of what you hold the fiduciary responsibility for?
Your Honor, the legislature is not required, we submit, in delegating the exercise of public trust rights to require, for example, if a telecommunications cable comes across the Atlantic from Europe, there's not a requirement by statute in Chapter 91 that DEP or the siting board consider, well, are the purposes for which that cable will be put in
I'm not
Europe.
talking about purposes. I'm not talking about purposes. If, in fact, there was going to be evidence that the fishing and fouling, adjacent to the Netherlands was going to be impacted, and, in fact, there would be no impact on the fishing and fouling in Boston Harbor when it snakes in underneath the harbor, no problem. I'm talking about where the project is so close to public land, and for the DEP and or EFSB to say, we can't look at that. I can't think of a case where that has been sustained.
There has never been a claim here, Your Honor, that the wind towers would impact
Because
fishing.
nobody's looked at it, because you have said that's federal jurisdiction.
There hasn't even been a claim in the federal proceeding, Your Honor, that the wind towers would affect fishing or fouling within Massachusetts. There have been various concerns that have been explored at great length in the federal
Isn't that the
process.
thrust of
And
the challenge to the delegation? I mean, Mr. Wilkins, forget the eelgrass. Mr. Wilkins is saying you have to look at the whole project because you're going to look at the impact. If you exercise your fiduciary responsibility, you have to look at what it is that you are licensing. That's what you are licensing. It's not as if you are licensing, to run this cable from here to the Netherlands.
Your Honor, we believe that this case is very similar to the court's holding in Villages, where under MEPA, the DEP wanted to look at the impacts of a very large development proposed on Cape Cod because a bridge going over a railroad right-of-way required a state permit. And the court held, no, one can only look at the impacts of the bridge because it's the bridge that is subject to the state permit.
Can I ask this a slightly different, get at this a slightly different way? If we were to conclude that EFSB could look at the larger project in the exercise of its fiduciary responsibilities or for other reasons, can we still uphold their decision in this case?
You've asked a question.
You mean because they've chosen not to? Is that what you're saying?
Because, well, I mean, you make an argument that the board reasonably confined its review to the impacts of the facility over which it had jurisdiction, understanding full well and acknowledging that there were other agencies deeply steeped in reviewing other aspects of the larger project.
And that's essentially, as you know, what this court held in, let's call it Alliance 1. The first time this same cable came before the court on a challenge to the permit, the board said, we're not going to look at the impacts of the wind farm, but we are going to make the cable subject to the condition that the wind farm get approved by the federal government after all of the appropriate environmental reviews. Those conditions still hold here, Your Honor.
So my
yes.
question is, assuming we were not inclined to say no, that the EFSB had no authority to look beyond the cables, would we have to send this back, or has there been a reasonable exercise of its responsibilities by essentially deferring on those aspects of the project?
I think the court would be free to reach the second conclusion. As to the first one, of course, we should, I think, be looking not at any statute in isolation, but we shouldn't lose sight of the language in the first sentence of Section 69K of Chapter 164 with respect to the certificate that says an entity may apply for a certificate for facilities in the Commonwealth, and then the board is to consider the environmental impact and public interest with respect to such facility.
All right, let me ask another question. Let's assume for a moment that DEP, this is focused on the Chapter 91 license, let's assume for a moment that DEP didn't issue a written determination that this license should issue, but in fact issued a written determination that it shouldn't. That it should not issue. Is it your view that the EFSB could essentially override that and make its own determination?
If there were grounds for the EFSB to move forward, that in and of itself might not be enough. But let's say, in addition, the Cape Cod Commission had denied the DRI application.
Right. Let's assume both of those things happened.
Yes. Then the legislature has delegated to the siting board the authority to decide whether the interests of the Commonwealth as a whole require that the cable go forward. It's hard, of course, although hypothetically, legally, one can understand the question, Your Honor. Practically, the standards that the board must apply under its statute are so similar to the standards.
No, Mr. Salinger, I don't agree with you. Public interest is not fiduciary. It is not fiduciary. Fiduciary is the very, very, very highest. It's not. Villages, as I recall, is a MEPA proceeding, is it not?
It is MEPA, Your Honor.
It is not a Chapter 91. It
Correct.
did not involve public trust doctrine.
Your Honor, yes, the public trust doctrine has fiduciary roots, and the legislature in Chapter 91 has said that in determining whether or not a structure may be or should be licensed in the tidelands, DEP, or we submit the siting board, should be looking at whether the public rights in fishing, fouling, navigation are preserved. Findings were made here that they are, and should be looking at whether the structure would serve an important public purpose, the benefits of which outweigh the detriment. The point I was starting to make, Your Honor, is that very similarly, the legislature has instructed the siting board under its statute to determine whether an energy facility would serve a public purpose of sufficient import after having ensured that environmental impacts are minimized, again, very similar to Chapter 91, that would warrant the grant of a certificate. So the specific concerns that the legislature articulated under Chapter 91 for the exercise of that fiduciary duty are quite similar to the specific concerns that the legislature articulated as the basis upon which the board is to act in granting a certificate that has nothing to do with Chapter 91.
So are you saying that the standard of review for the, if first of all, if we agree with you that the EFSB has been delegated the right to issue a license under Chapter 91, is it your view that the standard of review of EFSB's issuance of that license is subject to the same standard of review as all the other agency determinations that it made?
Yes, Your Honor.
So that we look to see whether the EFSB has exercised the highest fiduciary duty, correct?
If I may phrase it differently, Your Honor, the court would look to see under the normal 30A standards whether
No, not the normal 30A standards, because what you're looking at, it may say public interest, but the question is the level of scrutiny, and what I'm interested in is whether the public interest for providing for energy, which is real, important, substantial, and well documented, permits EFSB to say we won't look at the impact of the wind energy generating facility because that's out of our jurisdiction.
If I may, Your Honor, here's why I suggest that the standard isn't different even when one is dealing with a Chapter 91 license. One of the core aspects of judicial review under Chapter 38, of course, is whether an error of law has been committed. The question of whether an entity has violated its fiduciary obligation really amounts to a question of an error of law.
So we look essentially, you're agreeing with me, we look to see whether EFSB, assuming that we conclude that there was, in fact, an express delegation of the Commonwealth's fiduciary responsibilities to EFSB, that we then evaluate EFSB's decision-making under the fiduciary lens.
And what that lens is, Your Honor, if the court or a superior court were reviewing a Chapter 91 license issued by DEP, let's say, the question there would be, did DEP, in fact, properly apply the legal standards set forth by the legislature in Chapter 91?
But why DEP? Because we haven't had the DEP process.
I'm trying to show, Your Honor, that the standard that Your Honor just articulated with respect to the citing board, and thus the standard that, if this were a DEP case, would apply there, really does come back to the 30A standard. If it were DEP acting, to simplify it, and had issued a Chapter 91 license that's challenged, reviewing court would look to see, has DEP applied the legal standards articulated by the legislature in Chapter 91, Section 18, and in so doing, has its decisions been based on substantial evidence? If yes and yes, then it's a lawful exercise of the delegated authority. So the same standard applies here, Your Honor.
I'm not sure that what the EFSB board should be doing is the same as what DEP is doing under Chapter 91, because again, I return to, and you understand it's my concern, I mean, the EFSB board is saying, is this good for the energy needs of the Commonwealth of Massachusetts? Correct?
Yes, and that has been identified by the legislature as a very important public purpose.
Of course it is.
That's right.
Of course it is. So is economic development and all kinds of other things.
And Chapter 91 licenses are there so that structures that serve important public purposes can take place in the tidelands. This would be a much harder case if the citing board said, we think this is such an important project that it should go forward even though some one or more than one of the standards under Chapter 91, Section 18 are not met. This is not that case. Here, the citing board made findings, indeed adopted the specific findings that were in DEP's written determination that each and every one of the licensing requirements under Chapter 91 have been met for this project.
Thank you, Mr. Salinger.
Thank you, Your Honor.
Good morning, Mr. Rosenzweig.
Good morning, Madam Chief Justice, members of the court. May it please the court.
Could I ask you a factual question? Where does this stand at the federal level? I mean, some agency has designated Nantucket Sound to be something. I mean, is it still going forward at the federal level?
It is, Your Honor. You may be referring to the National Park Service that has come up with a determination that Nantucket Sound is eligible for listing as a traditional cultural property. The MMS, Minerals Management Service, is the federal agency that's delegated the authority by Congress to look at impacts from the wind park. And they are looking at all impacts from the wind park, frankly, whether those occur in federal waters or state waters. And there's been broad participation by all parties, including state agencies like DEP, as well as the parties here, to ensure that all of those impacts are actively considered. The process is nearing its completion after a 7-year, 8-year review process. There has been a final environmental impact statement that's been issued, and there's a prospect of a final decision, record of decision, issued by the Secretary of Interior in March or perhaps April of this year. So all of the issues that have been alleged, including impacts on fishing, fouling, navigation, the types of interests that come up under Chapter 91, are being considered by the Minerals Management Service, not just restricted to those impacts in federal waters on the Outer Continental Shelf. In that regard, I join the argument of Attorney Salinger on the interpretation of state law, but there is clear federal law here as well. The 10 taxpayer suit.
I understand that. Mr. Rosenzweig, I don't wish to re-question you about the express delegation, but I am interested in your response to one point concerning what the EFSB did here. In Mr. Wilkins's brief, he points out that the EFB said, and I assume that he is, I'm quoting from page 12 of his brief, the citing board declines to create an implied exclusion of Chapter 91 licenses from the scope of the certificate in the absence of a clear showing of the legislative intent to do so. Mr. Wilkins makes, it seems to me, not an unreasonable point that that is just flipping the burden upside down.
The authority granted to the citing board is indeed comprehensive. The words...
No, I understand that, but isn't what the EFSB did here is to say, well, you didn't exclude 91, and so therefore it's included, and the law is you have to expressly include it, otherwise it's excluded. And I don't know, and I haven't looked, I have to confess, I have not read the entire record here, but that just struck me as a rather fundamental error of the citing board. Maybe it actually didn't do that, I don't know.
Well, I take it go ahead, you may answer.
The legislature was unmistakably clear in Section 69K, granting the citing board express authority to issue all permits, approvals, licenses, other forms of authority or authorization.
Well, it doesn't use the word license, right?
It does 4 times in Section 69K and Section 69L. It describes licenses, and in fact, this court in the Agawam case granted a license. In a certificate case, the court affirmed the grant of a license. Licenses within the context of the permits, approvals, and authorizations, and license is explicitly referenced in Section 69K and Section 69L. But more importantly, where the legislature wanted to exclude particular license activities or limit them, they were explicit in Section 69K. They eliminated, or limited, I should say, the grant of a NPDES permit by the citing board. They limited or conditioned that the citing board may not grant a permit or license through its certificate authority that conflicts with federal water or clean air standards. And so the legislature was very aware that Chapter 91 applies to transmission lines, and that Chapter 91 rights are required. Chapter 166, Section 21 references for transmission lines their need to obtain Chapter 91 licenses. If the legislature had intended to exclude Chapter 91, given their knowledge of Chapter 91, they would have stated so explicitly in Section 69K. As this court said in the Providence and Worcester case, it's not up to the board or this court to exclude or impute things that the legislature has not provided.
So, excuse me, but I just want to be clear. You say all of the issues are being considered, right?
By the Minerals Management Service for the wind turbines, yes.
Mr. Wilkins says, no, they haven't considered the full effects. So he's wrong.
Well, if he's wrong, he may challenge that authority, whatever final license is granted by the Minerals Management Service. But his forum for doing so is not before the citing board or DEP when it deals with impacts that are expressly exclusive to the federal agencies. That's what the 10 taxpayer case stands for. And as Justice Botsford alluded to, there's express case law under federal law that where something is exclusive or preempted, a state agency cannot do indirectly that which it cannot do directly. And that's exactly what would happen here if the state agency, be they the citing board or DEP, were to consider impacts from the wind park.
Why? We're not trying to stop, you know, if they can get their transmission cables without going over public trust doctrine, we're not stopping them from doing that.
Yes, but if these...
It's not doing it indirectly. It's saying there are two very important jurisdictions here. It is no different than saying if they were trying to build this facility on a state park and you were the owner, trustee of the land next door, you're not indirectly stopping that. You're exercising your appropriate responsibility here.
In this case, it's the citing board acting in the context of Section 69K, where it's granted the same authority that DEP would have to issue licenses and to follow the same procedures that DEP would follow in granting licenses. And the citing board has to make express findings under Section 690 that whatever license or certificate it grants conforms with notions of environmental protection and safety, that the public interest, convenience, and necessity are addressed. Those are the same types of considerations that DEP or any state agency would make in granting any permit or approval. So with regard to the particular scope of this certificate, the legislature was eminently clear that it is
So why isn't it a conflict of interest here? I mean, if you, on the one hand, they're wearing a fiduciary hat for the tidelands, and on the other hand, they're wearing a public interest hat for the rest of the people in the Commonwealth. And why isn't there a conflict between the issuance of the potential issuance of the tidelands permit why isn't that being trumped by a bigger interest and adversely affected by a bigger interest for the good of the public as a whole?
If you're referring to the wind park's in federal waters and is not in the Commonwealth tidelands, so it's not subject to Chapter 91 licensing.
Its impact is subject.
And
its impact is subject.
Its impact is being considered by the federal agency.
No. By the Commonwealth in exercising its fiduciary responsibilities, surely. Surely. Now, you can say to me, I've exercised my fiduciary responsibilities and I've looked at that impact. And this is how I, as a fiduciary, have made that determination. But I hear you and the Attorney General, the EFSB, saying, I can't look at that. That's federal. That's preempted. That's not on my land.
Even the Fafford case recognizes at page 198 that even Chapter 91 is subject to federal law.
Well, of course it's subject to federal law. Nobody's doubting that. Nobody's doubting that.
Well, with regard to the particular issue of the cable issues were fully examined by both DEP and the
cable issues were examined. But the cable issues, it's not as if the cables go right up to federal jurisdiction and they've got nothing to do with a wind energy facility. The reason why you as the fiduciary, no, not you, Mr. Salinger as the fiduciary, is being asked to give you, a private person, the right to use public lands is so that you, a private person, on the next door property can exercise your absolute right, if you get the feds to agree with you, not my problem, that's a good thing to do on federal land.
This court in the First Alliance case recognized with respect to the siting board that it will be the federal agencies that will be making all the critical permit decisions, was the language of the court, with regard to the wind park. And it wasn't for the siting board to make its own predictions or to duplicate that review. And the same would go with regard to DEP. Those agencies will be undertaking that review.
No, I understand, Mr. Rosenzweig, and I have no idea, none, and I'm really not interested in the impact of your client's project on federal land. That's not my concern. But you might have some impact on Commonwealth land. And if the Commonwealth is doing something to facilitate the impact that you will have on Commonwealth land, I have to look at that, I think, through the public trust doctrine.
Unless it's vetoed. And the 10 taxpayer case said...
Unless what is vetoed?
Unless there's a veto because of preemption that the federal government's authority is exclusive. And so that if you got...
It's exclusive on federal land.
It's exclusive on federal land, but if you got into a situation where the state agency said, I don't like these impacts from the wind park because they do something undesirable in state waters or on state lands, but the federal agency said those same impacts were permissible and met its standards, you would have a clash of the authority of the federal government with the state government.
I don't know enough about the federal public trust doctrine to know whether that's the same. I really don't.
All those issues are being looked at exclusively and exhaustively by Minerals Management Service, and DEP has had a chance to weigh in on the public trust doctrine as well.
Thank you, Mr. Rosenzweig. Is that